Welcome to another episode of the Divorce and Separation Coach podcast. Today, we're going to be talking about a family judge's insights on dividing matrimonial assets. Now, we know that the broad rule is 50-50, but in reality, that is take into account a lot of different factors. So we're going to dive into that today, and I've invited Jackie Marks to discuss that with us. Jackie is a family law barrister, and she's got over 30 years experience. She also sits as a deputy district judge in the family court, and she's got a ticket to hear both private children and financial remedy cases. Jackie's also an accredited resolution mediator and one of the founding partners of the Mediation Space, which is a multi-disciplinary mediation service in which all the professionals are trained in psychoanalytic psychotherapy. Welcome, Jackie. It's so nice to have you today.
It's very nice to speak to you again, Chloe.
So can you talk us through the key principles that a judge will apply when settling financial matters?
Yes, well, the key principles are to share the fruits of the marital partnership. And as you mentioned earlier, the starting point is one of equality. But the other key principle is how to meet needs, and that can mean housing needs and needs in terms of maintenance to meet income needs. And the overarching search in relation to the application of those two principles is for a fair outcome. So sometimes the starting point of equality doesn't reflect a fair outcome because it doesn't meet needs, either housing needs, because a 50-50 division of the equity in the family home won't allow one party to house. So that might be a reason for a departure from equality. So the whole time we're looking for what will be a fair outcome to meet needs of both parties.
And you're looking at equality across the whole lot, right? It's not each individual asset that's looked at individually.
Yes, you have to have a holistic approach to all of the assets, and very often how to divide up how the equity in the house is divided up has an impact on the level of maintenance, because if one party has to have a much higher mortgage, it means that there might be less disposable income to pay maintenance.
Yeah, that's true. And so is there anything else that you take into consideration? And I'm thinking in particular, any kind of moral judgment, if there's been an extramarital affair, or if one of the parties has been abusive, does that find its way in the considerations for matrimonial asset division?
Well, very rarely. One of the court will consider a number of discretionary factors in reaching a decision about what is fair. One of those factors in the statute is conduct, but conduct is only ever considered if it reaches the threshold of what the court would describe as being inequitable to disregard. So it has to be really, really serious conduct, which usually has to have a financial consequence as a result of it. So, for example, if one party caused a very serious injury to the other party, which left them disabled and affected their future earning capacity, that might be conduct that would be not inequitable to disregard, but it really is very unusual for courts to take into account conduct, and certainly having marital affairs is not regarded as conduct, and the court doesn't make moral judgments. So although very often parties come to court thinking, well, why isn't that taken into account? Because that's a terrible thing that's been done to me. Not something that a court is going to be placing any weight on or really even wanting to hear about. So the factors that the court will be interested in are, if there are children, the welfare of the children, or the court's, whilst they're still minors, are the court's first consideration. The other factors are the income and earning capacity that each party has, or that it's reasonable to expect that party to acquire in the future. Their assets, their resources, what liabilities they have. The length of the marriage is important. What contributions they both made to the marriage. Sometimes somebody brings assets into the marriage which are wholly external, from wholly external sources that should be reflected, if they can be, to achieve fairness. Parties' ages, any disabilities that they have, those are also factors. And then finally, the statutory objective in each case is to achieve a clean break if the economically weaker party can adjust without undue hardship to the termination of their dependence. Those are the discretionary factors that the court will apply.
I think it's important for people to hear that, because a lot of times there's a tension that going to court is going to give you that big moment of emotional justice, where finally the judge is going to point out how horrible your ex has been.
Yes.
And it's hard for people to realize that it doesn't have an impact. Specifically, I'm thinking about affairs. People think that because there's been infidelity, they're entitled to more because they've been hurt. And it's hard to accept that that's not something that's looked at in that specific context.
Well, I would go so far as to say that's never looked at. It is just not going to feature, and the judge is not going to want to hear about it. And that's not to try and diminish the emotional impact on the recipient of that conduct, but it isn't conduct that is going to have an impact on the outcome of the division of the assets.
Yeah, that's important to understand. And so you mentioned gross misconduct when there's really a massive issue. Now, we know that with the new family procedure rules, if somebody is refusing to engage in non-court resolution, then it could be held against them in a cost order. But would it be taken into consideration in the division of assets?
Well, I mean, if one party is refusing to disclose their assets, that is regarded as litigation conduct. So there's a difference between conduct which relates to the way that the parties have related to each other during the marriage, and litigation conduct, which is how they've engaged in the proceedings. And litigation conduct can have consequences. It can have cost consequences for the non-disclosure. And the court can also draw inferences based on non-disclosure. And if the evidence supports it, conclude that that party does have assets that they failed to mention and take them into account. But those are the sort of issues, so if there's non-disclosure, that tend to lengthen proceedings and to make them highly contentious and much less likely to settle, unfortunately.
Assume it's not uncommon for people to try and hide a few things and keep them off their Form E.
Well, it's not uncommon, but equally, I'd say it's not uncommon for litigants to believe that the other party has not disclosed assets, and looking for that hidden pot of gold, in my experience, very rarely turns up anything. So it cuts both ways. So if one party has unreasonably pursued an issue that has created more costs in seeking to demonstrate something that just isn't capable of being demonstrated on the evidence, and that's also litigation conduct. People have to be realistic as well about what's achievable and what outcomes there are likely to be.
And also, I guess, take into account what that pot of gold might look like versus how much I'm gonna have to spend to find it.
Well, there is.
So
exactly.
if it's a couple £1,000 or even a couple dozen thousand, it's probably going to be spent on lawyer fees anyway.
Yes, exactly so. So it's about proportionality as well.
Yeah, absolutely. And so, are there ever times where a couple will come to you with a mediated agreement and you have to reject it? And if so, on what grounds would you reject it?
So yes, it does happen. So parties can send in consent orders to the court for the court to approve. So just to make it clear, the court isn't just a rubber stamp of agreements. The court has to be satisfied that those agreements are fair. And so the agreement must be within the band of reasonable outcomes to be fair, or it won't be approved by a court, by a judge. And also the drafting of the order must be clear and it must be precise so that it is understood. And that's particularly important because if further down the line there is a dispute about what was intended, it needs to be enforceable. So the language also needs to be very clear and precise. So sometimes agreements are rejected because they're demonstrably unfair, or they're rejected because they're not in clear and precise terms.
In establishing whether they're fair or not, you'll be using the same criteria you would if the case was coming in front of you.
Yes, I mean, if I saw a proposed consent order which gave all of the assets to one party and nothing to the other, leaving the other in a way that they're not going to be able to meet their housing needs, I would not approve that order. I would stop it and invite the parties to come to court to explain why they're saying that particular outcome is a fair outcome.
And so that's interesting. So it means that even if you have negotiated an agreement that you're actually happy to sign, if it's not favorable to you, if it's going to put you in a complicated situation, then it would be
Yeah.
rejected by the court. So the court is looking out for individuals as well.
Yes, exactly. It's to also protect the parties as well to
Yeah,
achieve.
absolutely. And so what happens if circumstances change after the divorce? So we've got this arrangement in place, and suddenly, I don't know, somebody has an accident, can no longer work, or somebody wins the lottery, or whatever it might
Yes.
be.
Well,
Can those be amended?
yes, well, in financial cases where there are capital orders made, and that is lump sums, property adjustment orders, or pension sharing orders, those are not reviewable or capable of variation. They're final orders unless there is non-disclosure that comes to light subsequently,
Okay.
which would enable the court to potentially set aside those orders. So usually that's the end of any further litigation in relation to those type of orders. But in relation to spousal maintenance orders, those can always be varied depending upon the payer's continuing ability to pay or the receiver's needs, if those have changed. So those are always variable. And as you say, if somebody wins the lottery and they're in a much better position to pay, well, that might be a reason for a variation.
What about child maintenance orders? Are those,
Child
can
maintenance
those be
orders,
amended?
yes, so if the child maintenance order has been made by a court, and child maintenance orders can only be made by a court if the parties both agree, other than in some specific circumstances where the payer's income is very significant.
Okay.
In case the court can make what's called top-up orders. Generally, child maintenance orders are made either by agreement by the court, or the parties will go to the child maintenance service, who will calculate
Yeah.
the rate of payment in accordance with the formula. But if there is a child maintenance order in court, then there can be a variation by the court, but very often, more usually, the parties will make an application for an assessment by the child maintenance service.
Yeah, it makes it a lot easier, especially if there's not a lot of money to be split. You don't want to be spending it on courts.
No,
So,
exactly.
so if I'm understanding correctly, I think you're saying what I usually tell my clients is these are agreements that you're going to have to live with in the long term. They're very unlikely to change, and you need to think about them twice before you sign on the dotted line. The judge will review it to make sure that it's viable as well, but it's something to consider carefully. And because I see people who say, "Oh, I can't be bothered anymore. I'll just sign whatever." And while in that moment, I completely relate to that feeling of wanting to move on with your life, you will be, constrained for quite a while if you're signing a deal that's not viable.
Yes, people do have to realise that they are going to have to live with the outcome. The flip side is, I see people that really bury their heads in the sand and just don't want to engage in proceedings because it is too frightening for them, actually. They're too scared of the outcome. And it's
Yeah,
easier not to engage rather than to try and find a solution. Because when you're filling in your Form E, which is the financial form, which sets out all your income and assets and liabilities, it starts to feel very real when you start to think,
yeah,
what's going to happen to the family home? How, where am I going to live? How are my needs going to be met? And when you hear what your ex-spouse's case is for the first time, what they're asking for or what they're offering, it can be very unsettling and very frightening,
yeah,
because you haven't yet reached a resolution and you're still arguing about things. And that's particularly so when both parties, as they very often are, still living in the same household. It's a very
yeah.
difficult period of time for them.
So do you see a lot of divorces going through and being finalized all the way to the decree absolute without having a financial order?
Well, not decree absolute, because usually the decree absolute is postponed until there is a financial order in
Okay,
place to protect people in relation to pensions, so that they're still the
okay,
widow or the widow if the pensioner passes away. But yes, I see cases in which the parties have separated many years earlier and have still not resolved their financial matters,
yeah,
either because they haven't, either because one of them's moved out and they've sort of had this sort of recognition that perhaps the other one's going to stay in the house until the children are a bit older, and then the children are a bit older, and then they want to try and resolve things, and
yeah,
5 years has gone by, and they're older, and their ability to borrow is perhaps more constrained when they're older. So, you know, delay can present quite a lot of challenges.
Yeah, that makes a lot of sense. Last question, which is one I usually ask, which would be, what would be your top 3 tips for somebody who is, or a couple, let's say, who is trying to divide matrimonial assets amicably? What would you recommend they consider and make sure they don't miss?
Okay, so first of all, I would say be prepared to accept that you may have to give something up and to make changes and to adjust your lifestyle. That is the reality, and you may just have to accept that that is the reality. Secondly, I would say make sure that you do make full and frank disclosure of your assets. Lay your cards on the table so that there is a transparent process, because if you don't do that, then you're going to find that the matter becomes highly contentious and takes a lot longer and costs a lot more money.
Yeah.
And thirdly, I would say, as soon as you possibly can, make realistic offers to settle. Make proposals. Don't hold out until you see what the other person's willing to offer. Make a proposal and start negotiating sooner rather than later.
Great tips. Thank you so much, Jackie. I think those are all really important for people to keep in mind, because they will make a big difference in how things unfold, and to how good the agreement is at the end of the day, which is really the objective, is to come out of the divorce with what they need to move on with their lives.
Yeah.
So that's really helpful. Thank you so much, Jackie. It was really nice speaking to you. And thank you for sharing all your tips. Thank you so much.
My pleasure, Chloe. Thank you for inviting me.
Have a great day.
And you.